Your Honor, the state's electing to proceed on 1244. We're asking the court punish this defendant as a misdemeanor.
With a state jail felony conviction.
Yes, Judge.
Good morning, sir. Are you Enrique Garcia III? And Mr. Tucker, will your client waive the formal reading of the indictment?
It would, Judge.
Mr. Garcia, in cause number 25 DCCR 1057, you're charged with the state jail felony offense of unauthorized use of a vehicle, and that's from June 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving him any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, Mr. Garcia, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail under section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Judge.
See, Donald Cogdale.
He's gonna be a little bit difficult. He's not combative. He's just.
Last time he said.
No, I'm telling you,
Okay.
make sure you, he's like questioning the, that was my thing 100 times. And
All right.
I thought they would just come back with another offer. I mean, this is the best offer. You know, try to go through it with it. He starts questioning me. I'm the judge. This is the judge. Well, I understand.
Good morning, sir. Are you Donald Cogdale? Are you Donald Cogdale?
Yes, ma'am.
And Mr. Cogdale, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is it's gonna be a lot better, worse. I don't understand.
What do you not understand?
This is a critical turning point. The judge is laying out the defendant's criminal history piece by piece. And it's not just background, it directly increases the possible punishment. In legal terms, prior convictions can elevate a charge into a much more serious sentencing range. Now the real question becomes, is 8 years a lifeline or a gamble worth rejecting? Because once you roll the dice at trial, the outcome is completely out of your hands.
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the,
Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay? I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
So go
I'm
ahead.
sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading, so we were actually even going to come to the court with seeking your permission for that 8 based on
Did
the
you
facts
catch
of the
that moment? That hesitation says everything. This sounds less like confidence and more like realization, the point where the reality of prison time finally hits. Many defendants reach this exact crossroads, fight the case, and risk a longer sentence, or accept the deal and move forward. So here's the big question for you watching. If you were facing up to 20 years, would you take the 8-year offer or take your chances with a jury?
for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute.
Thank you.